Welcome to the Law GH. Welcome to our lesson on constitutional law. First tutorial lesson on constitutional law. Today, we're looking at the nature and scope of constitutional law and constitutional supremacy and parliamentary supremacy. In this video, you need to pay much attention to the selected major authorities that will be displaying on your screen and use them when necessary. However, you also need to pay attention to the audio in order to grasp the tutorial so you don't miss what is unwritten on your screen. Commencement. Under the topic, the nature and scope of constitutional law, we have to appreciate that there are 5 areas to take out of this topic, namely 1. What is meant by constitutional law and the definition of a constitution. 2. The characteristics or features of a constitution, which is categorized into 2. The broader or general characteristics and the major characteristics of all constitutions. The next is the sources of constitution. 4. The classification of constitutions. And 5. The purpose for constitution in a country. Let us now examine the above objectives seriatim. In answering a question on the definition of a constitution, one needs to follow the structure below. A. Briefly provide a definition for what is constitutional law by using an authority from Hood et al. This is necessary because it is from constitutional law that a central idea of constitution is gained. B. State and analyze the scope of a constitution. This is where you indicate the 2 general types of constitution, the broader sense of a constitution and then the narrower sense of a constitution. C. Identify and explain the key terms operating under the broader sense and the narrower sense of a constitution, which include the legal rules, non-legal rules, hard law, soft law, high law, and fundamental law. D. You then begin to provide authorities for what is constitution. One may start this paragraph as, in order to provide the definition of a constitution, there is the need to identify certain legal rights and cases where a constitution was stated. After this, then you start giving your authorities for what a constitution is, supra. E. You need to analyze every authority you provide on the definition of a constitution in line with the broader sense and the narrow sense and where the definition is originating from, whether it fits a particular country identified or otherwise. By doing this analysis correctly, you need to have your definition that you will give for what a constitution is in mind, so you build your analysis around it and in line with the 2 senses supra. This part of your work is called the critique of authorities. F. In your conclusion, you acknowledge that there is no finalization as to what a constitution is, despite the sound propositions made by scholars and judges. However, you intend to provide what a constitution is. Then you give your own definition and that ends your discussion. Therefore, we humbly crave your indulgence. Sit and go through the lesson with us. Please don't forget to subscribe, like, and share. Grateful to you all. Key authorities. What is a constitution? Hood et al., Constitutional and Administrative Law, 5th edition. Constitutional law is the law relating to the constitution of a state. Thomas Paine. A constitution is not an act of government, but of a people constituting a government, and a government without a constitution is power without right. A constitution is a thing antecedent to a government of a country. Monroe. A constitution is the body of rules and arrangements relating to the government of a country. Sir Ivor Jones. Constitution is a document in which are set out the rules governing the composition, powers, and methods of operation of the main institutions of government, and the general principles defining the relationship between the state and the citizens. Per Wade and Phillips, Constitutional Law, 8th edition. A constitution is a document having a special legal sanctity, which sets out the framework and the principal functions of the organs of government of a state, and declares the principles governing the operation of those organs. Where? Modern constitutions. The word constitution is commonly used to describe the whole system of government of a country, the collection of rules which establish and regulate or govern the government. According to Marshall, in the case of Marbury and Madison, the institutions of government are set in place by the Constitution. The writing helps us to limit the propensity of power holders to exceed their limits. Justice Sowah in TUFFOUR and Attorney General at page 636 to 637. A written constitution such as ours is not an ordinary act of parliament. It embodies the will of a people, it mirrors their history. Account, therefore, needs to be taken of it as a landmark in a people's search for progress. It contains within it their aspirations and their hopes for a better and fuller life. The Constitution has its letter of the law. Equally, the Constitution has its spirit. It is the fountainhead for the authority which each of the three arms of government possesses and exercises. It is a source of strength. It is a source of power. The executive, the legislature, and the judiciary are created by the Constitution. Their authority is derived from the Constitution. Their sustenance is derived from the Constitution. Its methods of alteration are specified. In our peculiar circumstances, these methods require the involvement of the Pajoi whole body politic of Ghana. Its language, therefore, must be considered as if it were a living organism capable of growth and development. Indeed, it is a living organism capable of growth and development, as the body politic of Ghana itself is capable of growth and development. A broad and liberal spirit is required for its interpretation. It does not admit of a narrow interpretation. A doctrinary approach would not do. We must take account of its principles and bring that consideration to bear in bringing it into conformity with the needs of time. And so, we must take cognizance of the age-old fundamental principle of constitutional construction which gives effect to the intent of the framers of this organic law. Every word has an effect. Every part must be given effect. Perhaps it would not be out of place to remember the injunction of St. Paul contained in his first epistle to the Corinthians, chapter 12, verses 14 to 20, King James Version. For the body is not one member, but many. If the foot shall say, because I am not the hand, I am not of the body, is it therefore not of the body? And if the ear shall say, because I am not the eye, I am not of the body, is it therefore not of the body? If the whole body were an eye, where were the hearing? If the whole body were hearing, where were the smelling? But now are they many members, yet but one body. And so, a construction should be avoided which leads to absurdity. And when a particular interpretation leads to two, shall we say inconsistent result? The spirit of the Constitution would demand that the more reasonable of the two should be adhered to. We must have recourse of the Constitution as a whole. So, from the excerpt of the learned judge, your attention needs to be drawn to the part where he stated, a written constitution such as ours is not an ordinary act of parliament. It embodies the will of a people. It also mirrors their history. Account, therefore, needs to be taken of it as a landmark in the people's search for progress. It contains within it their aspirations and their hopes for a better and fuller life. The Constitution has its letter of the law. Equally, the Constitution has its spirit. It is the fountainhead for the authority which each of the three arms of government possesses and exercises. It is a source of strength. It is a source of power. The executive, the legislature, and the judiciary are created by the Constitution. Their authority is derived from the Constitution. Their sustenance is derived from the Constitution. Its methods of alterations are specified. In our peculiar circumstances, these methods require the involvement of the whole body politic of Ghana. Its language, therefore, must be considered as if it were a living organism capable of growth and development. Indeed, it is a living organism capable of growth and development, as the body politic of Ghana itself is capable of growth and development. A broad and liberal spirit is required for its interpretation. It does not admit of a narrow interpretation. In much more flowery terms, FRANCOIS JSC in NPP and Attorney General, 31st December case, a constitution is the outpouring of the soul of the nation and its precious lifeblood is its spirit. The constitution of a nation is not simply a statute which mechanically defines the structures of government and the relations between the government and the governed. Though that may be chief of its objectives, it is also a mirror reflecting the national soul. the identification of the ideals and aspirations of a nation, the articulation of the values bonding its people, and disciplining its government. The essence of a constitution, as Justice Jackson notes, is that it seeks to better secure liberty. Note: all references to Chapter 4 in the audio should rather be understood as Chapter 6 of the Constitution, unless the specific article is mentioned. Characteristics of Constitution. 1. It is a product of the constituent power. In the 1992 Constitution of Ghana, Article 1, the sovereignty of Ghana resides in the people. 2. It established the state, its divisions, and the system of government. See the preamble of the 1992 Constitution, chapters 8, 10, and 11 of the Constitution. 3. It is the law as well as the source of all legal power. This combination makes the Constitution the fundamental law, Article 1 Clause 2 and Article 2 Clause 1 and 2. 4. It is made up of the rules, practices, etc., Article 11 and Chapter 6 of the Constitution. Major features of all constitutions. 1. It contains the general ideas, aspirations, and values of the society concerned, Chapter 6 of the 1992 Constitution. 2. The Constitution should contain some information on the structure and organization of the government. 3. Information on the rights and responsibilities of individuals. Chapter 5 and Article 4 of the Constitution, including the entire Constitution. 4. Every constitution should contain rules for its amendment, depending on the history, experiences, and aspirations. Chapter 25 of the 1992 Constitution. Classification and focus of Constitution. Constitutions are variously classified. Among these are written and unwritten, flexible and rigid, federal and unitary, monarchical and republican constitutions. 1. Written, that is rigid, and unwritten, that is flexible constitution. This is based on the rules codified in a single document, written, and the amendment of the Constitution. If it provides special rules for its amendment, then it is rigid. If not, it is flexible. Thus, whereas flexible constitutions are relatively easier to amend, rigid constitutions involve elaborate processes for amendment, which may include a popular referendum. An example of a rigid constitution is the 1992 Republican Constitution of Ghana. The British Constitution is a flexible constitution. 2. Monarchical and republican. This is based on the attributes of the head of state, and it is a choice between the constitutions that provide for a hereditary, monarchical, and if to be elected for which is republican constitution. The election can be any, whether direct or indirect. A perfect example of a state with monarchical constitution is England. Queen Elizabeth is a constitutional monarch. For Republican constitutions, we have the 1992 Fourth Republican Constitution of Ghana. Nigeria also has a Republican constitution. This type of classification, in short, focuses on the source of legitimate power in the state. 3. Presidential and Parliamentary constitution. This focuses our mind on the relationship between the legislature and the executive. Where the executive is answerable and controlled by the legislature, then it is parliamentary, and where the executive is independent, it is presidential. In Ghana, we have a presidential constitution, as our president is not answerable to the legislature and controlled by the legislature. 4. Unitary and federal constitution. This classification is based on centralization or devolution of constitutional powers. Netherlands and Nigeria are unitary and federal respectively. If we have the same institution of government at the center and also create regional or state government, then we have a federal government. Example, US and Nigeria. On the other hand, when our government arrangement is put into one single structure and government is located at the center, then we have unitary constitution. Example, Ghana. Sources of constitutional law. 1. Organic law or legislation. 2. Judicial decisions. 3. Customary law. 4. Textbooks or writings of highly qualified people. 5. The history and experiences of the state. 6. Constitutions and practices of other states. Make sure you do not confuse the sources of constitution studied in this course with the sources of law as studied in the Ghana legal system. Some additional keynotes. When a constitution is said to be a fundamental law, it implies that it is a document from which is derived the main organs of government. Also, a constitution said to be higher law means that the laws set in them are out of reach of alteration by the legislature or capable of alteration by some solemn act, which is distinct from the ordinary one of the legislatures. Note that, in law, the passive language or voice takes higher preference and not the active language or voice. Let's quickly turn our attention to the last aspect of today's discussion: constitutional supremacy and parliamentary supremacy. This aspect of the study of constitutional law seeks to differentiate between the concept of constitutional supremacy and the concept of parliamentary supremacy. A case study for this aspect of our tutorials will be the comparison between Ghana and the UK constitutional law regime. Therefore, please pay attention to the presentation while you observe a few of the authorities displaying on your screen. Please don't forget to subscribe to this channel, like the video, and share the link. Commencement. Key things to focus on: A. What is constitutional supremacy? B. What is parliamentary supremacy? C. Identify the features of the two systems. D. What are the mechanisms or how does the two systems operate under their respective regimes? E. Additional information to the two systems. Constitutional supremacy means that the Constitution is supreme and that Parliament can exercise its functions only within the bounds of the Constitution. Constitutional supremacy is possible only where the Constitution is written and rigid. On the other hand, parliamentary supremacy, according to A.V. Dicey, Parliament has power to legislate on any subject, that is, the width of the legislature. No parliament may be bound by the legislation passed by a predecessor parliament, nor may one parliament bind its successors, that is, length of the legislature. No other body has the power to override or set aside the law made by Parliament, that is, supremacy of the legislature. Characteristics of constitutional supremacy: 1. The Constitution is written. 2. The Constitution must be rigid. 3. There must be in the Constitution, either express or implied, a declaration that this Constitution shall be the supreme law and any other law inconsistent with the Constitution shall be void. 4. The legislature is created by the Constitution itself and it exercises its legislative power within the bounds of the constitutional limitations. 5. There is a distinction between constitutional law and ordinary law. 6. The Constitution must outline the structure and system of government and distribute powers. 7. The Constitution must provide rules for its amendment. The next aspect you need to examine under this topic is to look at the relationship between the Constitution and the organs of government. Finally, under constitutional supremacy, the Judiciary, that is the Supreme Court, is the central organ, whereas under parliamentary supremacy, the legislature is the central organ. Authorities. According to Yardley, constitutional law is the law that is concerned with the constitution of a country. Professor Hood Phillips says that to say that a constitution is supreme is to describe its relation to the legislature's power to alter the constitution as either limited or non-existent. Article 1, Clause 2 enacts, "This constitution shall be the supreme law of Ghana, and any other law found to be inconsistent with any provision of this constitution shall to the extent of the inconsistency be void." Article 2, Clause 1 also provides that a person who alleges that A. An enactment or anything contained in or done under the authority of that and any other enactment, or B. Any act or omission of any person is inconsistent with or is in contravention of a provision of this Constitution may bring an action in the Supreme Court for a declaration to that effect. The FRANCOIS JSC echoed in Adolfo and Attorney General. This constitutional provision unequivocally and authoritatively establishes a doctrine of supremacy of the Constitution in the Ghanaian jurisdiction. The doctrine implies that the supremacy of Parliament is limited and that enactment by Parliament and those of previous legislatures are subject to the supremacy of the Constitution. The Supreme Court, also a new patriotic party and Attorney General, 31st December case, FRANCOIS JSC, as he then was, in his opinion in support of the majority decision, was clear about legislative or parliamentary actions using the constitutional litmus test as provided under Article 1 Clause 2. He said, "In my view, even though Parliament has the right to legislate, this right is not without limit, and the right to enact a law that June 4th and December 31st should be declared public holidays cannot be left to linger in the realm of public policy. Such legislation must be within the parameters of the power conferred on the legislature, and under Article 1 Clause 2 of the Constitution 1992, any law found to be inconsistent with any provision of the Constitution, the supreme law, shall to the extent of such inconsistency be void." In the same 31st December case, FRANCOIS JSC, also in support of the majority decision, said, "Parliament now has no uncontrolled right to pass laws on public holidays, any more than it has to declare a one-party state or make a party leader president for life or crown him emperor. As fundamental or basic law, the Constitution 1992 controls all legislation and determines their validity. It is for the courts, as guardians of legality, to ensure that all agencies of the state keep within their lawful bounds." Ejechim and Attorney General. Fact: Mr. Bright Akwete, the second defendant, a lawyer and citizen of Ghana, on January 16, 2006, sent a petition dated January 15, 2006 to the President, with a copy to the CJ. Further copies were sent to the JBA, the AG, and the Judicial Secretary. The petition sought the removal of the CJ on the grounds of judicial misconduct and abuse of power. On March 9, 2006, the President's Press Secretary issued a public statement that, in compliance with Article 146 of the Constitution, the President was setting up a committee to inquire into the petition. Subsequently, the plaintiff complained that the appointment of the committee by the President to inquire into the petition was unwarranted and unconstitutional, since inter alia no prima facie case has been established against the CJ, as required by Article 146 Clause 3 and Clause 4, which mandates the establishment of a prima facie case prior to the setting up of a committee to investigate complaints in a petition against a justice of the Superior Court, of which the CJ was one. Per Datiba JSC, the CJ must be given the benefit of a prior determination of whether a prima facie case has been established against him before the President might lawfully establish a committee to consider a petition for his removal. Where there was a substance in any allegation leveled against the CJ in a petition, the requirement for a prima facie determination would not stop the process of holding the CJ to account. The question of the prior prima facie determination and the subsequent appointment of the committee were to be made by the President in consultation with the Council of State. It would be prudent for the Council of State to evolve a convention by virtue of which the advice of a reputable independent lawyer would be sought as part of the consultative process with the President. You need to also note the case of Blackburn and Attorney General to help you understand what is meant by supremacy of Parliament. Revert to the cases under the nature and scope of constitutional law once again. Questions. 1. Differentiate between sovereignty of Parliament and supremacy of Parliament. 2. Can we have constitutional supremacy and sovereignty of Parliament operating under one constitutional regime? Justify your answer. 3. Use the expressive code of Justice Sowah in the video to provide your own analysis and definition of a constitution. 4. Can a country or state exist without a constitution? Justify your answer. 5. To what extent is the two topics discussed in this video under constitutional law relevant to the study of constitutional law? The end. Thank you for paying attention to our first lesson. Please remember to subscribe to this channel, put your notifications bell on, like the video, and share to colleagues, friends, and family. And also write a comment below in order to serve you better. Catch you later with different tutors and lessons. The Law GH.